It's the morning drive.
Good morning and welcome to the Morning Drive. I'm your host, Brooks Fessinger of brooksfessinger.com and millionairewho.com, where we help you stabilize your wallet, secure your future, and succeed in entrepreneurship and finance. I'm here with my co-host today, Hyundai Sonata. All right, let's get on the road. So what are we going to talk about today? Well, predominantly, I would like to talk about ideas and protecting our ideas. In addition to protecting our ideas, we'll talk about intellectual property because that plays in quite a bit with this concept of protecting our ideas. So I want to start off talking about a real thing that happened to me pretty recently, a couple of weeks ago. I was perusing Facebook and spending real high quality time seeing what people are up to and talking to other individuals. And I noticed these ads kept popping up for this thing that essentially writes letters to you. And the idea behind it was, instead of trying to print out letters, this thing will actually use a computer to write with like a ballpoint pen, like actually write the letters. Therefore, it really is a signed written letter as opposed to a computer printed letter. So the idea being, this would be a lot higher quality. The your customers would appreciate it. Whoever you send it to would appreciate it because now you're able to send them like a real actual written letter, despite the fact that a computer is doing it, and therefore you can kind of pretty much mass produce it. So, it's kind of an interesting idea, and your first thought could be, okay, is it a good idea, is it a bad idea? That was moot because the fact of the matter was, I invented that. So, I'm sitting here saying, up, whoa. Here's somebody doing the system that I created, I invented, that I revolutionized. I was like, this is crazy. I had tried to bring it to market. I tried to sell it to major players. I didn't have success. That's in another podcast if you want to read about it. But I'm sitting there saying, okay, so this does everything that doesn't do everything that I invented, but it's a piece of the system that I invented. I sat there and said, I've got to do something about it. So I call up a lawyer and I asked my lawyer, I said, hey, here's what's going on. So this other guy is doing the same thing that I invented, and I got a patent for it. So, obviously since I have a patent for it, I'm fully protected, and there's nothing that, they can't be stealing my idea and using it. I guess you can steal ideas. They can't steal my process and use it. So my lawyer says, hey, I'm not a patent attorney. Let me put you in touch with a patent attorney. And when I put you in touch with a patent attorney, then you can get this figured out and get this rectified. So that's pretty much what then happened. He put me in touch with the patent attorney. And I talked to my patent attorney, and I go through this all with him. And I send him information on the patent that I have, right? Because I have a patent. That's the whole reason I spent all that money, pretty much my life savings on this patent at the time, was because I didn't want somebody to come along and profit off of what I invented. I looked at the years of this thing. He came out several years after my patent was published. My thought is, hey, I'm protected. What's going on here? And that's when things got a little dicey, you see, because when you write up a patent, it has very, very specific language. And the issue I realized pretty quickly was while I had a patent, it was approved by the Patent Trademark Office. It was very, very specific, down to the point that it pretty much says, like, you have to use the letter A at this point in this way. And my entire time I had this patent, I was paying maintenance fees and stuff like that. I was under the impression that I was fully covered from somebody else using the idea. And when I was talking with the attorney, I realized that my patent was so specific that it was just about useless, right? So I don't want to say it was totally useless. Once again, this isn't a done situation, so this could come up. Maybe there is a case here, but at least in first review, it raised the question of, is my patent even broad enough to cover somebody who does anything besides actually steal my code and use it, if that makes sense. So, you're running this issue with patents that they can be so specific that it literally says, like, if Brooks Fessinger is the only person who touches it, and it happens inside his house, and if you're doing somebody else's house, you're not covered. And the problem is, you feel like, okay, I've got a patent, I got everything taken care of, and frequently that's not the case. I've frequently, looking from the other standpoint, I've come up with products and releases where I had to make sure I wasn't infringing on somebody else's patents. In those cases, you research the patents, you look into them, and you sit there and pretty much find the gotchas, right? You're like, okay, I'm cleared because it doesn't do this, or I'm cleared because, I build on this substantially, or, I'm cleared because of various other reasons with the way the patent's worded. And so, in my life, patents have never really held me back from doing anything I wanted to do. So any idea I had, there might have been patents in the area, but ultimately I was able to work around the patents in pretty much every situation. And now the same thing is kind of facing me, and I'm sitting there saying, okay, so I dumped all this money into this patent to protect myself so that nobody could take my process, no one can take my invention. And here I am facing a situation where I can't protect my invention from those who are taking it because the patent was worded so precisely that I don't even know how to prove that they were indeed replicating what I did. I don't know if that makes sense, but just to give one more analogy, it would be as if your patent said, hey, I'm patenting a sign. The sign has to be exactly 27.3 millimeters wide, and it has to be Kelly green. And somebody else makes it 24 millimeters wide and makes it a darker green. And then all of a sudden, it doesn't overlap your patent at all. And it's frustrating because you can sit there and say, well, that is what I invented. That was what I tried to patent. But that might not have been precisely how your patent was actually written and how your patent was actually built. And that gets into this concept of intellectual property and what do you do. I feel it necessary at the beginning of this conversation to point out that I am not a lawyer, and you should seek out a lawyer for any advice related to the law, right? I'm not allowed to practice law, therefore I can talk about what I've done, and I can talk about these general concepts. I do teach this stuff. I've taught business law, and I've taught this stuff, but I cannot give you specific law advice. So there's four predominant ways to protect your ideas, and one of them is a trade secret, one of them is a copyright, one of them is a trademark, and then one of them is a patent. We're going to start talking about what is a trade secret. Trade secret is this really, really complex thing where you have a secret and you keep it, right? So I know somebody out there who's a paralegal or a lawyer is going to say, wait, it's a little more complex. Yes, it is a little more complex than that. But for the most part, a trade secret is a legally permitted secret or privacy that doesn't have to be disclosed about a process or a recipe or a system or whatnot. And trade secrets are often protected big time by companies because they really are an asset. They're of value to the company. But if the word got out about what the trade secret is, there's nothing they can necessarily do to protect it. The only protection they have is they have the legal ability to prevent others from learning about it. So that's pretty much what a trade secret is. And so once again, it's this idea that you can preserve secrets that give you a competitive advantage in the marketplace, and that secret is some form of intellectual property, as in, something that you own or you can protect, right? To keep other people from taking it. Now, intellectual property is really any of your ideas or concepts or creations. And I started giving you an example about a patent, and we just talked through trade secrets. The next three that I'm going to talk about, copyright, trademark, and patents, are all like things that you actually file or specific protections given by the government. You don't always have to file a trademark. We'll get in a minute. But the idea is you're trying to protect your intellectual property or your ideas from others. And this is actually something that comes to me all the time, because I can't tell you how often somebody tells me, hey, I got this great business idea, or I got this great concept, or I got this great thing, but I can't tell anybody. I got to wait until I get my patent, or I got to wait until I get my stuff. And we'll break that down at the end. But any of this stuff that you're trying to keep from other people falls in this category. And almost every business has some type of competitive advantage generated from some sort of intellectual property, whether, once again, it's as simple as a trade secret or it's as complex as a patent. They have something in those fronts protecting what they've created to give them competitive advantage. So, if you're coming up with your side hustle, you're creating your business or your corporation or whatever it is, you're going to be dealing with intellectual property probably from day one, because you're going to be sitting there saying, how do I protect myself from it? And what do I need to do? And the vast majority of people I talk to that are starting up side hustles or businesses ask me about, how do I protect my brand, or how do I protect my product, or how do I keep somebody else from copying this? How do I get a patent? How do I get this? These questions come up all the time. So I'm guessing you're thinking about it, or you will be thinking about it soon if you're not thinking about it right now. So after the trade secret, which is really just a legally allowable keeping of a secret, you have a copyright. And now copyrights are pretty interesting, because a copyright will cover a creative work. So for example, a story, a poem, a picture, something that you create. The interesting thing about copyrights is that two things: they last forever, they last a really long time, and you don't actually have to do anything to get a copyright. So the minute you create something, a book or otherwise, you own the copyright to it. You don't have to file anything to own the copyright. Now, there's a lot of tricks you're going to hear online, and I can't advise you on these, but there's a lot of tricks that you hear about ways that you can prove that you were the creator of something at a certain time period, therefore you can sustain the copyright. Because if you can't prove that you were the creator, then that's when you lose the copyright protection. So you don't actually have to file anything, but you might want to file something for some benefits, including the fact that you can prove exactly when it was created, what the date was, and that becomes difficult to challenge in the future, where if you just publish something on your own and it's hard to track down who did it and when, it's a lot more challenging to create those protections. So a copyright actually is valid for 70 years after the death of the author. And compared to any other type of intellectual property, except for trade secret, that's intense. 70 years after the death of the author is a really long time. In most cases, that is, beyond even the heirs of the creator. So patents last, or copyrights last a long time. If you create something when you're 10 and you die at 90, then you get 80 years of it, plus another 70 years, right? That's 150 years of copyright protection where you own the rights to it, your family owns the rights to it, your heirs own the right to it, and others don't. There's a little different when you're dealing with something called a work for hire. A work for hire is, for example, when you publish somebody else or hire somebody else to create something for you. Those are good from 95 years from first publication, or 120 years from the creation, whichever one of those two comes first. So once again, you're good for about 95 years. Again, that's a really long time. That's beyond the life of your company. That's beyond your life in virtually all situations. So that's a pretty big deal. And that's one of the huge benefits of copyright is you really do have longevity. You're protected for a really, really long time. Again, it doesn't have to be registered, but it only costs $35 to register a patent. I think it's a little more expensive to use a credit card, but you can just contact the government, USPTO. You can register a copyright. That's the R. You'll probably see the C with the circle around it. That's copyright. You don't need to file anything to have a copyright. But if you see the R with the circle, that's a registered copyright, and that means it's been registered with the government. So when you register with the government, there's a lot of benefits. For example, you can actually sue in federal courts where you can't do that if it's not registered. You get protection from the U.S. Customs if somebody else, for example, it's a movie and somebody else brings in a fake from another country, you're protected. And then the big thing, though, is you have that public record. And that public record is incredibly important because if you can't prove that you were the original person that owned it, then you will have no protection if you need to take legal action around the copyright. So therefore, that date is worth it. So frequently, if this is important to your side hustle or your business, what's the harm in paying $35 to get a registered copyright, right? It's not that much money. It gives you a lot of protections, a lot of benefits. Now, I will honestly tell you that even though I'm telling you it seems like a no-brainer, I haven't done it. I have not gotten a single registered copyright on any of my stuff. I do have copyrights on everything. So what you're watching right now is copyrighted. You cannot copy this. You cannot distribute this as your own because I own the rights to it just by creating it. I don't have to register anything to own those rights. So once again, that's a copyright. You don't have to register anything. But if you do register something, you get the perks. It's not that expensive to register. So once again, if it's integral to your side hustle or your business, it's hard to argue against taking the effort to do it and just getting that copyright filed. All right, next up on the docket, we've got a trademark. So what is a trademark? A trademark is essentially your identification in trade. And what that includes, it can include a range of things from a specific logo to a specific slogan to a specific use case of a name. And some people are going to say, you can't copyright names, you can't do that stuff with names, but you can trademark these. However, they're tied to the specific use that you're trademarking. So trademarks are a little finicky because, I can't trademark the name Brooks and say no one else should use Brooks. But I could trademark the name Brooks in a certain stylized manner used for the creation of, financial business materials. There you'd have a trademark and you can file this trademark and that trademark has no expiration. So if I've got a company that uses the Brooks name for this educational stuff, 300 years from now, they can still be protected under trademark law. The trademark costs right now $225 to $400 for the application, and once again, that gives you protection for that mark in trade. So trademark, use that mark, which is whatever that logo or specific use of something is in trade. And in that filing application, you actually have to give specific examples of where you're using it and how you're using it. So you can't just sit there and say, hey, I'm going to trademark Bob Smith. You've got to go in there and say, here's how I'm trademarking it, here's where it's used and used right now in trade, and here's specifics. Like I've got to upload pictures of it in use. So that's kind of what a trademark is, and trademark keeps other people from essentially being able to take your likeness for use of trade. So for example, you take the Ford logo for Ford cars. They've got that trademarked, so somebody else can't make something that looks just like the Ford logo to sell cars where people will think it is Ford logo, right? Because then that other company is using the goodwill built by Ford. Goodwill is essentially the idea of how much value is in the name or the brand that's created. So if you think about when you go to the store, you often pay a lot more for the mainstream brands, and that's because you have trust with those brands and or you're supposed to understand what you're going to get. There's value in that name, and trademarks protect that value in that name so that somebody else can't take your identity, and that's the idea there. So I have trademarks, and trademarks make a lot of sense for a lot of businesses to make sure somebody else can't take your mark in trade and use it, right? So I can't sell a Ford car. I can't sell a General Motors car because those logos and those are trademarked. Therefore, I can't take them. And that trademark can be valuable. And so once again, I've got one, including for oneforum.com. So once again, somebody can't take that specific form of that logo or use case and combination and use it in trade, because that would be in violation of my trademark. And if you don't get a trademark, sometimes it can be hard to prove that you have rights to it or who came first, and that sort of thing. And so once again, registering a trademark helps give you the establishment of when and how, and gives you some of that protection. So once again, in a lot of use cases, trade secrets, copyrights, or trademarks are going to be the path that you want to take. They are the more affordable options, and they give you some pretty substantial protection as long as they cover whatever it is you're trying to do. Now, the last thing I want to talk about is patents, because this tends to be the first thing people ask me about. Is they said, hey, I need to patent this. What do I need to do to get a patent on this? And normally I sit there and tell them, okay, so you need, $40,000 and a heck of a lot of time, right? It's kind of my go-to statement. Can you do it cheaper? Yeah. Can you do it more expensive? Yeah. But what is a patent? A patent gives you protection to your specific design for a specific product or system. There's two kinds of patents. You've got utility patents and you've got design patents. Now, design patents are exactly what they sound like. You are patenting the design of something. So that could be something like, the specific design of a car, or the specific design of a lunchbox, or the specific design of a cell phone. So somebody else can't take off the specific design that you have. And these are good for 14 years, and once again, cover the specific design. Many patents, however, are what we call utility patents. So utility patents, they cover the function of something. So while design is like the actual look of something, the utility patent is the actual function or the utility of that design. So you can probably figure it out pretty quickly. A utility patent covers more per se than a design patent does, because it actually covers somebody else changing the design but keeping the same utility of whatever is patented. So most people find a utility patent is what they're looking for when they think of wanting a patent. They want the utility patents. Now, utility patents, they're good for 20 years, which is pretty substantial, right? But they require ongoing maintenance fees in order to retain the protection. So I forget the exact years. I think it's 3 years, 5 years, 8 years, something like that. You actually have to pay more fees to maintain patents. And if you fail to pay the maintenance fees, then you will in effect lose that patent protection. So once again, even though you get 20 years from filing or from it being approved, in addition to it being approved, you do have to pay continued maintenance fees. If you don't pay the continued maintenance fees, you will lose those patent protection. So how does the patent process work? First of all, they can be expensive. Not only do you have fees that you have to pay the US government, you're going to have to hire a lawyer. And somebody's going to say you can do it yourself. And this gets back to that issue of, okay, what are you going to do with a patent you write yourself? Okay? Because patents in themselves are darn useless, right? A patent is only as good as its enforceability. And just because you have a patent doesn't mean squat if you can't enforce it. So, you're more than welcome to go file your own patent, but can you write it in such a perfect way that nobody smarter than you that's a lawyer can get around it? That's where you run into the challenge. So, in my case, I actually hired a lawyer to do it, and still I didn't choose a lawyer that helped me write it the right way. And it was still written in a way that, I'm not going to say it's not protectable. It is protectable in its specific way, but it doesn't cover everything that I wanted it to cover as the inventor. So I'm an inventor and I invented this thing and I want it to be protected in a certain way. That's not what the lawyer did. The lawyer didn't write it up the way I would have wanted it to be done. But if I would have written it up my way, it would have been useless as well, because I would have written it up in a way that literally would have given me zero protection at all, and it would have gotten rejected from the patent office and would have been literally useless. Why waste all that time in something that you can't do anything? Because in practice, you've got to take your patent and go into court and sue somebody and hire a lawyer to sue them and sit in front of them and say, here's the wording in my patent. You violated the patent, therefore you owe me damages, or you have to stop what you're doing, or whatever it ends up being. And that's only as good as the words and as well as it's written up. It has nothing to do with how good your idea is. It has nothing to do with how good your design is. It has nothing to do with how good whatever it is you invented is. It's how good it's written up. It's like a contract. And so you're only protected as good as it's written up. So my advice is strongly that you need a lawyer. I can't imagine anyone doing it without a lawyer. Can you technically do it? Yes. But if you're not a lawyer or a patent attorney yourself, then you're putting all that effort into something that's pretty useless. Now, if you just want to be able to tell people it's patented, sure, go for yourself. You can tell people it's patented. But then you're not going to have any luck if you try to take it to court, right? So you really don't have any intellectual property. You have a marketing tool. If you're looking for a marketing tool, fine, do it yourself. But seriously, a patent is only as good as the way it's written up, and therefore you're going to want an attorney. Definitely going to want an attorney for that. You can optionally file a provisional patent, and this is the one thing that you could possibly get away with doing it yourself. So a provisional patent is kind of like a holding place. It gives you like a 1 year to file the full patent, but it gives you essentially the ability to talk about it, but still prove that you were the original inventor. So you can still enhance and fine tune your invention after you file the provisional, but the provisional gives you kind of the filing date and the legal verification that you had created on a certain date, therefore allowing you to work on things and disclose things. I had always heard kind of the rule of thumb that you have 1 year after you start disclosing it in order to file something, and there's some truth to that. But the big kicker is you've got to make sure you are getting your full patent filed to the point, because if somebody can point back and say, hey, you made your patent information publicly knowable 2 years ago before you filed a patent application, your patent's not going to be valid. It's going to be void. And what use is spending $40,000 and having a void patent? That's a waste of money. It's a better way to spend $40,000 than throwing it down the toilet. So, once again, you get an attorney, you do it right. Maybe you do a provisional patent and then hire an attorney, because you can start selling things under provisional patent, which can be effective for some people if they sit there and say, look, it will be patented, but I don't have the money to patent it, but I can do a provisional patent, and then I can go start to sell this thing, get someone to buy it, and then with the proceeds, either have the buyer or myself file the final patent paperwork. Now, in that case, you always have to run the risk of having the patent denied, but you should have done your homework before you filed a patent anyway, and you've always got that risk. So, again, that's kind of how that provisional patent can play out for you. So, again, patent gives you some pretty good protection, some pretty good support that can be worthwhile for many, many, many inventions. And therefore, a patent could very well be the right solution for what you are trying to do. Again, they're good for 14 to 20 years, depending on what you get. But I highly recommend you get a lawyer. I highly recommend you vet a lawyer so you get a good lawyer that understands what they're doing, and that they write it up in a way that's going to give you the protection you need for releasing your product. Once they give you a patent, don't just trust, hey, a lawyer wrote it. Reread the patent yourself and say, hey, does this cover what I want it to cover? Or is it too specific? Is this so specific that it's not going to cover anything at all? Or is this so, covering just a little piece of what I built and not the other piece? Those are the kind of things that you're going to want to address with your lawyer before the patent application is filed. Now, I've told you, I always use the price of $40,000, and someone's going to say, hey, I can do it a lot cheaper. You can do it a lot cheaper, but be prepared to put in a lot more time and effort than you realize when getting a patent filed. And $40,000 isn't unrealistic. $20,000 is very doable for first-time filers if you get the right attorney. If you get down to like $2,000, I'd be questioning the attorney you're using, because it's a lot of work to file a patent. But again, it is technically possible. So once again, you got the filing fees, but then you also have the law fees, and you've got to draft. I mean, patent applications are pretty meaty documents. You got a lot of back and forth with the government, USPTO, when you're filing those things. So again, use a decent lawyer and get that drafted up. All right. The last thing I want to talk about today is we're talking a lot about protection, and protection's important. Intellectual property is important. Protecting your inventions and your systems and your trademarks and your copyright, it's all important. I'm not going to downplay it at all. But I want to tell you, don't let your fear dictate your ability to succeed. So many people I talk to never get started because they're so scared of somebody stealing their idea. If you're so, what's worse, the risk that somebody could possibly steal your idea or the risk of not doing it at all? And that's bigger is the risk of not doing it at all. Most people don't have the time to deal with your patents. They don't have the time to deal with your invention. They've got things going on in their own life. And maybe if you're inventing something that's going head to head with a competitor, they're going to watch it and try to replicate it. And there's a place where you got a lot of validity. But if you're a small player, nobody's watching you. Nobody's trying to steal your idea. Your friend doesn't care. Your parents aren't going to steal your idea. Your sister's probably not going to steal your idea. So being fearful of everybody around you, and therefore that preventing you from being successful moving forward with your ideas, is foolish. And go get the intellectual property that you need. But if you sit here and say, I can't afford the intellectual property and I'm afraid to talk to anybody about it, so I'm just going to do nothing. Doing nothing is the worst thing you can do. You'll have other ideas. You'll have other inventions. I've thought I've had the best invention in the world every 3 months for the last 20 years. You're going to come up with other ideas. And chances are you've got something great and you want to move with it. So move with it. Move with it, right? I'm not telling you don't get the protection. Get the protection, but don't let fear of somebody else stealing from you or fear of other people keep you locked up and keep you from being able to start moving the needle on your dreams and your ideas and your goals. Don't let other people do that to you. Fear is, a powerful force that shouldn't be. Most of your fears are never going to happen. And this is a perfect example of, once again, don't let your fear of someone stealing your ideas completely derail your future and your goals and your dreams, right? You need to make them happen. Thanks for watching. Hopefully you learned something today. Now go out there and make the impossible happen.
Learn more at MillionaireWho.com.
It's the morning drive.